right, hopefully you all enjoyed that little question and answer. For those of you who stayed, it looks like we've got some that stayed and some new folks, so welcome back. I think we're ready. If you'll call the next case, please.
State of Tennessee versus Paul Rogers.
Good morning.
Good morning, Your Honors. If I may please reserve 3 minutes for rebuttal.
Okay.
And may it please the court, my name is Autumn Bowling. I'm here on direct appeal on behalf of the appellant, Paul Rogers. I've raised 3 substantive issues on this appeal. First, that the trial court erred in denying probation solely because of the nature and circumstance of the offense without necessary findings and using improper considerations. Second, that the trial court erred when it sentenced Mr. Rogers to full or complete confinement. And 3, that the record shows that Mr. Rogers did in fact meet his burden to being a suitable candidate for probation or other alternative sentencing. I'd like to start with just a brief recitation of the facts as they happened. Mr. Rogers was seen at a gas station by an officer who ran his tags for an unknown reason. The tags came back as not on file. The vehicle left. The officer followed and attempted to stop the vehicle. This vehicle did not stop, and a pursuit on the interstate occurred. The officer's patrol car tried to box in the vehicle. The car turned to the right and then turned to the left, hitting the patrol car. Mr. Rogers pled guilty by information to 9 counts, the lead count being an aggravated assault with a deadly weapon, a Class C felony, as a Range 2 offender, and received a sentence of 8 years at 100%. A sentencing hearing was held thereafter to determine the manner in which Mr. Rogers would serve his sentence, which could have been probation, split confinement, or full confinement. And that's what we're here appealing today, is the manner of service that the trial court imposed, which was complete incarceration.
So he was Range 2 on a Class C felony?
He was, Your Honor. And that was all agreed to at the original change of plea hearing. So the only thing up for debate on this matter was the manner of service. And so I'm going to start actually with substantive issue number 2, which has to deal with the trial court sentencing him to full incarceration as opposed to split confinement or anything else. And so the core of this is that full confinement went too far. There is no reason on the record or explanation or finding that split confinement would not have been an appropriate sentence. And this is problematic because the Sentencing Act requires us to impose the least severe measure necessary to achieve the purpose for why it is imposed. And in doing so, the trial court made some comments on the record, but those comments only dealt with why probation may not have been suitable. And that comment in particular was that the trial court commented there was no way it was putting somebody on probation for committing an aggravated assault against a police officer. And this only took out any consideration perhaps for probation, but not split confinement.
The court was aware that it had the authority to impose split confinement though, right?
I'm sorry, Your Honor.
So the court was aware that it had the authority to impose split confinement, right?
Yes, Your Honor, at the
In fact,
beginning.
it mentioned it at the very beginning of the hearing.
Correct, Your Honor.
And so split confinement is simply where the court could order someone to serve in custody for up to a year with the balance of the sentence, in this case the 8-year sentence, suspended to probation. So when the trial court is talking about how the defendant is not an appropriate candidate for probation, isn't the trial court also talking necessarily about split confinement?
No, and I would say not, because an alternative sentence can be probation or split confinement, and split confinement, there's a different burden between defining your suitability between probation and just alternative sentencing in general, which is in the brief. And so I would say that no, just by precluding probation does not preclude all alternative sentencing. Probation is just one form of alternative sentencing. And so with his comment—
What's the different standard?
So the different standard, I have to reference my brief again.
I mean, because just the way that I've seen it most often, including in my own practice, is that I'm typically considering as a trial judge all forms of alternative sentencing, measuring all of the factors in Trent, for example, about why an alternative sentence would be appropriate. And then only after I've determined that an alternative sentence is appropriate am I going further than that. But you're saying there's a different standard that applies to weighing of probation versus something else?
That is what I've briefed, and I'm looking for it right now, but to kind of go back to another reason why I would also support that is that under the confinement factors, which is 40, 35, 103, 1A through C, under that, those are the confinement factors. So if any sentence is going to involve confinement, you have to look at those as well. So I think that since you have to go to the confinement factors later, if you're going to consider any kind of confinement, there's no qualifier in that statute as to whether it's only a year or if it's full confinement. It just says confinement.
So the trial court in this case did go to the 103 factors though, right? So for example, the very first factor is where the criminally accused has a lengthy criminal history, and we need to have a sentence of incapacitation, for example. And I think the defendant here had 4 prior felony convictions. Is that right?
I believe he had, I believe 4 is correct. There was a lot of dismissed conduct
And
that was
then-
discussed.
Right, but 4 felony convictions, maybe as many as, and you'll help me here, but as many as maybe 17 misdemeanors?
I don't know about the total number of misdemeanors.
A
There were
substantial
several,
amount.
there were several
Okay.
misdemeanors that were property related in nature.
One of the other factors also is where measures less than confinement have been previously or frequently been applied unsuccessfully. In this case, the defendant had his parole revoked one time.
He had, Your Honor.
had several probation revocations, including one for absconsion. And, of course, then the middle factor is when granting an alternative sentence would unduly depreciate the seriousness of the offense, and the court clearly considered that here. So it looks like we have, in this case, the trial court, when it's considering confinement, split confinement, full confinement, is adhering to the 103 factors, right?
I'm not sure that I would still agree with that. I do
Okay, why
think
not?
that, I think that by his particular comment, he is particularly saying probation. We know that probation and split confinement are both forms of alternative sentencing. And his particular comment was, I can't give you probation. He says nothing about alternative sentencing generally.
So if the court says, I don't think you're an appropriate candidate at all for probation, doesn't that necessarily include split confinement? Because the majority of I guess there would be a 7-year probation sentence following. And so if the court is concluding that you're not appropriate for probation at all, and it's made the finding about the 103 factors, isn't split confinement necessarily included in that rationale?
So I no, and I would disagree with that. In preparing for today, I looked through some of the newer cases that were not available back when we had the briefing. And there's a particular case, State v. Jerome Cole, 2025 Tennessee Crim Appeal, Lexus 428, that is actually from the same trial court. And one of the distinguishing, even though this court upheld and affirmed the manner of service in that case, there was actually the same trial court put on the record, I can't give you split confinement after discussing probation. And so even by just looking at that, I do believe that there's still, even this trial court is believing it should go through and talk about whether split confinement is also appropriate.
We don't do that, though, with other forms of alternative sentencing. So with community corrections, for example, there's not a requirement that the court go through community corrections analysis after it has denied an alternative sentencing. We've held that on a couple of occasions. So if that's true with respect to community corrections, which is under a different statute, is governed by different metrics, why in the world would we require that for split confinement as opposed to other forms of alternative sentencing? Why does the trial court specifically have to mention, I'm denying probation, I'm denying split confinement, I'm ordering a full sentence of confinement?
Well, I would go to one at the fact that at the beginning of the hearing, he's recognizing that it is going to be one of the particular alternative sentences he's considering. And so says he's going to consider it. And second of all, again, because it is, the Sentencing Act requires us to use the least severe measure necessary. Again, I'm still disagreeing that probation necessarily encompasses split confinement. But because he's going to impose some sort of confinement, the least restrictive measure of that at that time would be some form of split confinement or another perhaps alternative sentence. But one, I think to community corrections, my understanding is that community corrections is not available in Knox County, so I don't believe we would even go through that analysis. It's really not relevant
But what I'm
here.
saying, though, is that the Supreme Court in Bice, and I know you've got a separate issue with that, does not require magic language, doesn't require a particularly detailed sentencing announcement. It requires an announcement sufficient to know that we know that the trial court considered the alternatives. And so in that context, the trial court here recognized that split confinement was an alternative sentence that it was being asked to consider. And in other areas of the law, we have said that a trial court is not required to announce on the record that it has specifically considered other forms of alternative sentencing, such as community corrections. And so that led me to my question then, if we don't have to put on the record specific denials of other forms of alternative sentencing, why is split confinement special? Why is it that Bice would otherwise require us as a matter of putting the trial court in an abuse of discretion for not simply having mentioned it?
I think then perhaps another way to discuss this would be that the probation and complete confinement are the total extreme ends of our sentencing spectrum. Everything else is in the middle. Everything else is an alternative sentence in the middle. And he has said, I'm not going to give you probation. I'm not going to give you the extreme left end. But to get to full confinement, again, we're still looking back at the Sentencing Act. You have to impose the least restrictive measure necessary. And there's no reason given, there's no connection of the factual findings to why full confinement is necessary. So even if we don't have to say why split confinement isn't necessary, I do believe that we do need to talk about on the record why full, complete confinement is necessary if we're going to impose it. That's why there are specific, separate statutory considerations for confinement.
So are you saying that the trial court in this case went through all three factors? I think Judge Greenholz pointed that out earlier of 40-35-103, found that the defendant had a long history of criminal conduct, found that it was necessary to avoid depreciation of the seriousness of the offense, and found that measures less restrictive have been unsuccessful, particularly noting that this defendant had a prior evading similar in the past. So are you saying that the trial judge addressing and weighing all those factors and saying because of those three things I'm ordering confinement, are you saying that's not enough?
I would say it's not enough because in kind of jumping to one of the other issues in the brief is the reason why the trial court did impose confinement. And it goes back to this particular comment at the beginning. So after the trial court mentions these confinement factors, it delves into, it goes into kind of its final, I'll call it its conclusion, which is that in good conscience, I can't put someone like who does this particular crime, who commits an ag assault against a police officer out on probation. And that's really, it appears the conscience is the reason why the trial court is imposing confinement.
I know you argue that, and that, I mean, we can talk about whether that, statement was okay or not okay, but it seems like you're hanging your argument on the fact that that one statement was made, and that's the sole reason that the trial court made its decision. But when I read the record of what the trial court did, I don't see that. It again appears that the trial court weighed all of those factors and said, based on all of those things, I'm ordering full confinement.
So, and I read it differently, obviously. And so the way I read it is that while he's looked at these factors, and he's required to do so if he's going to impose confinement, what he finds that applies is the nature and that's why he's going to impose it, is because of the nature and circumstances. Perhaps the other confinement factors may have some weight,
Well,
but
they do
he's
have weight,
saying
though, right?
that
They do
he
have
says
weight.
that candidly, yes, he says that in the record, but what the trial court moves to is what he's talking about. Why he can't in his conscience is because of this particular offense. I can't do it. I can't put you on probation. I have to do confinement because in my conscience, I can't put someone out who has committed an aggravated assault against a police officer. The trial court has pigeon-toed itself into saying, I call it almost like a policy, saying anybody who does this in my courtroom, I can't give you probation, and that's based on the nature and circumstances of the offense.
But
That is
that's
what
an
he's.
appropriate sentencing factor, though, right? I mean, that's don't hold me to it, 103(1)(b), maybe, right? That says that confinement can be ordered when it's necessary to avoid depreciating the seriousness of the offense. And so by itself, that could be a sentencing factor. As it turns out, it's not by itself here. Why couldn't the trial court consider that? The statute specifically allows the trial court the ability to do so.
The trial court can consider that. I do not disagree with
Sure.
that by any means. I still disagree, though, that there were other considerations that were the basis of the decision. Again, I agree they are mentioned, but in the way I read this in the full context is what the trial court stops on and says, why I can't give you the probation, why I have to give you confinement, is because of the nature of this case, that it is an aggravated assault against a police officer. And that, if that's the only consideration, it has to use it has to go to the Trent standard and find any other egregious, has to find egregious conduct beyond the elements of the offense, which there is no finding about that.
Well, but there is though, right? So about a year ago, this court came down, in fact, it may be this panel, frankly, came down with a decision in State versus Donovan. And I can't remember who the trial court judge was in State versus Donovan, but my recollection is that it was also out of Knox County. The argument there was that the trial court had only used the seriousness of the offense to deny an alternative sentence. And we said no, there were no heightened requirement, findings requirements there because there was a criminal history that the trial court considered, for example. In this case, we have a substantial criminal history. He's range 2, so therefore he's not presumed under the old language, but should not be thought to be a proper candidate for alternative sentencing now because he's range 2. We have a previous history of probation revocations. Was he on parole at the time that this occurred?
I believe he had expired all of his sentences, at least in Knox County.
Okay. Was he on parole at the time that this occurred?
I don't believe so.
Okay.
There was some question about some Blount County cases, but.
He has a previous criminal conduct that he served time for that's substantively identical to this one in terms of evading arrest. All of those factors are weighing into the analysis, it looks like, with the trial court. So maybe the trial court's giving a special weight to one, but it seems like it's giving weight to others as well. And so, Trotter and Trent actually would not require the heightened findings, would they?
And so even if it doesn't, and even if there is other considerations that this court would say were weighed and considered in the imposition of the sentence, I still would go back to the in good conscience part. That is not a factor under the Sentencing Act, and that does appear to be a very strong, if not the primary reason why. And again, going to the nature and circumstances of the offense. And in talking about his conscience and not being able, the trial court using its conscience to not be able to impose a sentence, that's inappropriate under the Sentencing Act. Our job is to, everyone in this room who is an attorney, we are to uphold the law, even if sometimes that our conscience objects to it. And
well, what
based
about
on
this? I mean, as I'm reading the transcript, I think the in good conscience language appears, I think maybe with respect to rehabilitative efforts, right? So it says, and so I hope, Mr. Rogers, that you're sincere that you've made the changes in your life, but I cannot, in good conscience, risk this community by letting you back out. We've tried and we've tried, you have not responded. And so it looks like, at least in that perspective, the court is saying, I always have to consider the rehabilitative potential of the accused. We've tried. We've tried so often with you. You have not responded. Effective rehabilitation cannot be obtained, and I, in good conscience, cannot ask another member of this community to be your victim before you decide that you're going to engage with rehabilitation. It doesn't look to me like that statement, in good conscience, is talking about the nature of the offense. It looks like it's talking about the failure of rehabilitative efforts previously.
I would disagree. And I think in talking about rehabilitation, I mean, right above that paragraph, the trial court recognizes that I think he's got a decent potential for rehabilitation. He's taken some steps this time, he's getting older. And so the trial court is recognizing that rehabilitation is possible. And in the third issue of the brief, we discuss.
Well, I think we all have potential for rehabilitation, right? It's unrealized, though. And I think that's what the trial court's saying here is we've tried, it's just unrealized.
Even that, then so, the other considerations that the trial court may have undertaken, those still do not point to a sentence of full confinement. There's still no, there's nothing in there that the court finds any kind of terribly egregious or above anything other than what has just happened. And, you know, in talking about his criminal history, he says it's not the worst I've ever seen. We don't get into really the facts too much other than when the trial court says, I can't have somebody out here who does this, an ag assault against a police officer, which, again, we are coming to an idea that there is a policy that if you commit that particular crime, that is the court is going to generalize you rather than giving you an individualized sentence.
I don't know if you can see that you're out of time. If you want to use your rebuttal time, let me know.
No, thank you, Your Honor. I'll save my rebuttal.
Thank you. General Coleman?
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the judgments because the trial court properly exercised its discretion in imposing confinement for the otherwise agreed upon sentence. And before I get into that analysis, I think my friend on the other side has done a great job of explaining the facts, but I think there are a few that were left out. So, especially given the setting we're in, the factual background here is that police were at a gas station and they ran the plates on the car that the defendant was in. And those plates came back not belonging to that car. So officers attempted to initiate a traffic stop and the defendant began to flee. They then tried to box the defendant in and he effectively tried to ram his car into theirs. They ended the pursuit, but shortly thereafter, and I think this is some parts that weren't necessarily included, shortly afterwards they found the car. They brought a drug dog there, or they brought a canine unit, and it was able to lead them to the defendant, who was a short distance away. Inside the car, they found some documents that belonged to the defendant, not only having seen him drive, but then placing him in the car. A subsequent search of the car revealed the presence of a needle and 2 glass smoking devices. So he was charged with a plethora of things, of evading arrest, aggravated assault on these police officers, and some drug offenses. And he ultimately entered a sort of global plea to all of these for an effective 8-year sentence for 9 different convictions, again, with the manner of service to be left to the trial court. I know this court has gone over some of the trial court findings. I know it's been discussed, but I think, again, given the setting, I want to go almost step by step as to what the trial court's findings were before getting into why those were reasonable. So first, and I think it's important to note, the first thing that the trial court points out is the defendant's potential for rehabilitation. Before even getting into its considerations, it acknowledged the defendant has done some things while he's been incarcerated to learn some lessons, and I hope that will be fruitful. Even still, before it even gets into its considerations, it points out the potential manners of service. It says the court can place him on probation. The court can order him to serve a split confinement, or the court could order him to serve in the penitentiary. Having set that scene, the court then goes into its considerations. It talks about how it considered the arguments that had been made, exhibits, evidence from the pre-sentence report, principles of sentencing, arguments by the court, the nature and characteristics of the criminal conduct, and even the defendant's allocution that he made at the sentencing hearing. After making those sort of generalized considerations, it looked at the statutory factors on whether confinement is an appropriate manner of service. And this court has acknowledged those are the 3 factors laid out in Tennessee Code Annotated 40-35-103A. So turning to the first factor, the question is, does the defendant have a long criminal history or an extensive criminal history? And the court found that he did. It acknowledged, and this wasn't just sort of a giving lip service. It pointed out the defendant's criminal history isn't the worst that the court had ever seen, but it acknowledged he had several felony convictions and misdemeanor convictions for both theft and burglaries. And more important to the trial court, it pointed out he had 2 prior convictions for evading arrest, one of which did involve the risk of death. And so it was particularly concerned about that, and it sort of transitioned into the second consideration, or the second statutory factor, which
So,
is...
General, let me stop you here briefly. With the 4 felony convictions going all the way back to, I think, to 2016 sentencing, moving forward, is this his 3rd felony conviction involving a separate period of confinement or release? I mean, because if it is, he wouldn't be entitled to an alternative sentence anyway. So he had I think, a D felony in 2016. It looks like he had another D felony that was sentenced in 2020. This is being sentenced in 2024, 25. Is this the 3rd? Is he being sentenced for a 3rd felony involving a separate period of confinement or release?
Your Honor, the record would be more accurate than my recollection. Candidly, I did not write the brief. I've looked the record over, but off the top of my head, I'm not entirely
I mean,
sure.
your friend's asking us, she hasn't made the argument here today, but in the brief she's asking us to do a de novo review. And even in a de novo review, if he's being sentenced for the 3rd felony or more involving separate periods of confinement, you couldn't even have an alternative sentence anyway under the statute.
If that's what the statute says and that's what the facts back up, then that certainly makes this
Okay,
court's
fair enough.
decision
Okay, all right,
easy.
sure. Okay.
Again, I've got the pre-sentence report pulled up, and I just can't tell from a quick scan whether there were separate periods of confinement,
Okay.
or if two of those felonies sort of were
Had expired before.
expired.
Right, okay.
So, assuming, just in case, that he was eligible for probation, again, the trial court made that first consideration of his criminal history. It then looked at the deterrent effect and pointed out that this was an evading arrest that, could have caused serious injury. And pointed out it was not only a risk of death or injury to these officers, but other people in the community. Anyone who had been driving on that road or been walking nearby or playing in a field were placed in danger. So confinement was warranted because it proved an effective deterrent to other people who might think to flee in this sort of same situation.
General, if I could ask, this is a 100% service rate on this, correct?
For ag assault, that's my recollection, yes.
And it appears as though I believe the trial court might have been operating under the assumption initially that it was a 35% under range 2. Am I correct about that?
I don't recall seeing anything in the record with
It's at
that.
the very end
It
of the
says
sentencing
8
hearing.
years at 100%.
At the very end of the sentencing hearing, there was a discussion about the percentage of service before parole eligibility.
So on page 15 of the record, the court sentences you to serve at 100% in count number 1, 8 years. So it seemed to understand that. I think the count 2, which I don't remember off the top of my head, it mentioned was 35%, but it acknowledged that count 1, the aggravated assault, both at the start on page 11 or 10 or 11 and at page 15, that this was a 100% service rate.
Okay.
So again, that goes towards the deterrent level as well. And in conjunction with that second factor, the court looked at the deterrent, the specific deterrent on this defendant, and said, I don't think it's going to have that much effect one way or another. So it's not just giving lip service. It's not just making these generalized findings. It's truly considering them. And then third, it looks at whether measures less restrictive had frequently or recently been tried unsuccessfully. And I think that's where a lot of this language that the court and my friend on the other side have pulled out. It talks about how he had violated probation several times, how he had been revoked on parole for violations before. But then I think, and I hate to read from the transcript, and I know this court has it, given the setting, the students don't have it, and I want to emphasize exactly what the trial court found with regard to the language that we're talking about. And noted, I do think we've tried and been unsuccessful clearly on that. And going on to page 15 of the record, I think he's got decent potential for rehabilitation. He's taken some steps this time. He's getting older. That is the language my friend on the other side pointed out. Immediately afterwards, the court says, the problem is he's done the same thing, this evading arrest in a vehicle, creating a danger to others. This time, he made it even worse by almost killing some officers the way he was driving at them. And then going to this in good conscience quote, I hope, Mr. Rogers, that you're sincere, that you've made changes in your life, but I cannot in good conscience risk this community by letting you back out. We've tried and tried. You have not responded. So this wasn't sort of, this court should not cherry pick specific language by the trial court. It should look at the findings in the entirety of their context. And here, when the court is connecting the bases for those statements to the statutory factors, it's reasonable. The court wasn't just going out on a limb. It was tying those statements back to the statutory considerations. So after making all of those findings, the court determined that confinement was appropriate, and that's what we're here for today. Ultimately, and I think it's important to note what lens this court reviews that determination under. I know it was discussed in the briefs. It might not have been discussed today, but pursuant to binding Tennessee Supreme Court case law, this court reviews, especially when a trial court makes the relevant considerations and places its reasoning for imposing the sentence it does on the record, this court reviews that decision for an abuse of discretion and gives it a presumption of reasonableness. And under that lens, this court should affirm the imposition of confinement because the trial court very clearly laid out all three factors that it was considering. It explained the reasons why. It said some things weigh in the defendant's favor. He's shown some progress. The deterrent factor I don't think is weighing, it doesn't weigh in either way. But here are all of the factors that weigh heavily in favor of confinement. It stated its reasons on the record and then determined that confinement was appropriate.
So I think if I can restate your friend's argument, what I understand her to be saying is that the court didn't specifically weigh the incapacitative effect in a split confinement sentence. So I think what she would say, and in fact probably did say, was something like, all right, fine, you don't think that full probation is warranted and that some confinement has to be imposed, but you went from 0 to 60 instead of 0 to 30, recognizing that in split confinement, you're going to have some period of confinement that will carry along the benefits from that. You're going to be excluded from society for a little while, so you're not committing new crimes. Hopefully this emphasizes there are consequences to actions. Hopefully maybe you take advantage more of the rehabilitative efforts that are being offered in that context. And that the trial court did not consider then those aspects that would come inherently with split confinement and just went all the way to full confinement. I think that's what the argument may be, or close to it. What's the response to that? I mean, the trial court mentioned split confinement on the front end, but didn't talk about it specifically afterwards. So what's the best response to that?
So I don't mean to steal your own words, Judge Greenholz, but I think your questioning and responses point to what the appropriateness was. So the trial court determined that the defendant was not a good candidate for probation. A sentence of split confinement inherently contains a sentence of probation. Part of it is in a prison or a jail, but the remainder of it is served on probation. And if you're not a good candidate for full probation, you are also not a good candidate for partial probation, and that's reasonable. And again,
Except that, and I'm not arguing your friend's case for you, but except that I think she would come back and say, but it's not just full probation. Here you have a reminder that actions have consequences. Here you have a reminder through the taking of your liberty for maybe up to a year with that. And so split confinement inherently is a different type of punishment than full probation.
certainly.
So
But
why shouldn't the trial court have to put that on the record?
because a trial court is not required to go down a checklist. Instead, it has to make the relevant considerations and then give the reasons why it's imposing the sentence it's imposing. Like you mentioned, the court doesn't have to go every single time it imposes confinement. It doesn't have to say, here's why I'm denying community corrections on top of probation. Here's why I'm denying split confinement on top. Here's why I'm denying jail workhouse on top of probation. Here's why. I believe the statute provides 7 or 8 different possibilities for alternative sentencing. And in no way is the trial court required to go down that list and explain the reasons why it's denying each one of those. Instead, again, viewed in the lens of an abuse of discretion with a presumption of reasonableness, we look at, did it give reasons for why it imposed the sentence it did? Here, the court looked at the confinement factors, weighed them, made applicable findings, and then explained its reasons. Because you haven't been rehabilitated yet, because this was such a serious offense, because you have this criminal history, including offenses that are the exact same here. You haven't learned your lesson yet. That's why I'm imposing confinement. And that's what this court looks at. Ultimately, that was a proper exercise of discretion. And unless this court has any further questions, we would ask that you affirm the judgments. Thank you.
The first thing I did when I sat down was went back to my brief to find this standard that it seemed as though I had misquoted, because I certainly did not want to leave the court with an improper standard. But in looking back at my brief on page 25, I have cited, to be sure, quote, "A trial court's determination of whether the defendant is entitled to an alternative sentence and whether the defendant is a suitable candidate for full probation are different inquiries with different burdens of proof." State v. Richards, 2024, from this court, Lexus 400, citing another case, State v. Boggs, out of this court.
So what are the different burdens of proof then? What are they?
So I did not cite those, and I went to try and look those up right before, but I did not have internet connection, unfortunately. But while not being able to specifically answer your question, what it does appear, though, from just recognizing that they are two different inquiries, is that the trial court would have been required, especially considering it recognized on the front end that split confinement was available, that it needed to tell on the record why split confinement would not have been suitable, or at the very least, why complete confinement was necessary to effectuate the whatever purposes it did decide confinement was necessary for. And by not doing that, at the very least, the case should be remanded back for at least those findings, because split confinement was available, and as we believe, his suitability, while maybe it wasn't for full probation, under this standard that any other alternative sentence, which may be one of the 7 or 8 that are in our statute, but we're focusing on split confinement, that there was no, I would disagree with what my friend said, that the trial court believed it was a heavy weight to many of the factors. I don't believe it says heavy weight anywhere. In at least one of them, it says, I think it weighs in favor of some level of confinement. This factors may be true, but there was no heavy weighing, and there was nothing that specifically said, again, he has to be fully confined, other than, I go back to, it's the full nature and circumstances of this offense because it was an aggravated assault against a police officer.
So let me ask maybe the uncomfortable question. If we apply bias, do you lose?
I don't believe so.
Do you only win if we do de novo review?
No. I believe that by not discussing at all why split confinement or any other alternative sentence was not.
What about fines? I mean, fines is the very first alternative sentence that's listed. I don't know of a single case that says a trial court has to go through and say, I'm not imposing a fine in this case.
Well, and based on what the Richards case is saying about this, the quote is just that it's alternative sentencing. That's a different inquiry for all alternative sentencing versus full probation. And so I don't know that we have to go into the weeds on every different alternative sentence, as the court, I think, is suggesting I might be arguing. But at the very least, it has to make a different inquiry between full probation and any other alternative sentence, and just say whether there's another alternative sentence that could or could not be sufficient, as opposed to the very next part, which would be full confinement, which is, again, we believe that he skipped a step, which is an abuse of discretion, whether the court would apply bias or not, give me a de novo review. Either way, by skipping that particular part of the analysis, it's an abuse of discretion, and this case should at least be remanded back for findings on that particular issue. But we would ask for it to be remanded for a full sentencing hearing, or in the event, resentence Mr. Rogers to split confinement. Thank you, Your Honors.
Thank you.
Thank you both very much again for your good briefs and your arguments today. And we're going to step out and let the students talk with the attorneys. And we will be back for our third argument at 1:30.